is parliamentary consideration of the audit report. Then 3, there are actions to be taken, which are take the relevant steps to implement the recommendations of Parliament on the report of the Auditor General, or give explanations in writing to Parliament on why the report has not been acted upon. The law itself actually anticipates failure to act on those reports with reason. Honorable Senators, there is a principle in law called the subsidiarity principle. The subsidiarity principle in law dictates that a dispute must be resolved at the lowest institution competent to resolve it. So, for example, as a litigation lawyer, if I have a case that can competently be handled by the High Court, but when I look at the law, it can also competently be handled by a lower court, a magistrate's court. I am obligated to file that case in the magistrate's court, which is the lowest court competent to hear that dispute. We now know that the County Assembly of Meru has not exercised its mandate by seizing these reports and making necessary recommendations or steps to be taken to implement the report. Instead, it has picked the reports and come to this house with those reports. I want to believe, speaking for myself, that that is overburdening this very busy house. I want to suggest to you, Senators, that if you set a precedent here in these proceedings, that a county assembly can do that, it means that if we get a year where there are 47 county governments with some issues, and you know better than I do, that virtually every year, every county government has some issues in the audit report, it is possible for county assemblies to bring here 47 impeachment motions. I suspect that that may break the functional machinery of this house. I think that you better take a position in this matter that reminds county assemblies that they also have a role to discharge. To sit, invite relevant officers of the executive, interrogate audit reports, resolve disputes that can be resolved there first, then come here with only such residues of issues that the relevant officers have proved to be incorrigible. That is my humble submission, distinguished Senators. There is a cadre of claims before you where I submit respectfully that the County Assembly is in fact the author of the problem. Then it has brought the governor here. The alleged failure to appoint the chairpersons of the Meru County Revenue Board, Meru Microfinance Corporation, Meru Youth Service Board, and Meru County Investment and Development Board. I invite you to look at the correspondences at pages 53, 54, 57, 58, 60, 61, 62, 65, 67, 84, And the document at pages 85 all the way to 163, and the document at page 135 of volume 1B of the governor's documents. I will not read them, but save just to summarize that these are the multiple correspondence between the office of governor and the office of the clerk of the county assembly. There is no doubt, distinguished senators, that the governor nominated persons to these offices. If the governor did not furnish sufficient particulars, the county assembly had the option of rejecting those names. Just consider them and reject them, so that there is no jam in the system, so to speak. What has happened here is that for more than 1 year, the county assembly has engaged the governor's office in correspondence, but failed to make a decision on the chairpersons of these boards. And yet there is nothing the governor can do without the county assembly first making a decision one way or the other. The law, for example, distinguished senators, requires that ambassadors in this country, cabinet secretaries, be appointed by the president, but upon approval by the National Assembly. If the president were to forward names of cabinet secretaries to the National Assembly, then the National Assembly takes 1 year engaging the president in correspondence on those names without making a decision on them. Then eventually moves a motion to impeach the president for failure to appoint. That is malice in the extreme. I have reflected on the various categories of malice. I submit respectfully, this will fall into the category of malice of the highest order. This is a teaching aid in malice. It is inconceivable that there can be a higher grade of malice than this. You have been told that the governor has failed to implement the recommendations / resolutions of the county assembly. You are taken through the letter by the clerk claiming to be forwarding a resolution of the county assembly. In fact, that letter, when you look at it, it says that the Hansard is also enclosed. We have asked for that Hansard. We have asked for that resolution. Distinguished senators, it has not been presented to you. The question is, how will you impeach the governor on the strength of such an allegation? But more importantly for me, questions were put here to a number of witnesses to show who that report of the assembly of the committee of the assembly is addressed to. That report was addressed to the petitioners, not the governor. Who was that report copied to? That report was copied to the various officers who allegedly the petitioners had sought to be removed from office, one by one. That report was neither addressed to nor copied to the governor. But now you are told to make a finding that the governor failed to implement that report that was neither addressed to her nor copied to her. As a matter of fact, can we say that in accordance with the law, the County Assembly of Meru has established this fact? I repeat, it is not in my place to make that determination. It is in your place, distinguished senators, to make that determination. I invite you to make that determination with this factual matrix in your mind, so that you vote that in good conscience, a governor who is neither the addressee of a letter nor copied in the letter can be removed from office on an allegation of failure to implement the contents of that letter. Factual matters on the dismissal of Dr. Ntoiti, Paul Mwaki, Kenneth Kimathi Mbae, and Joseph Kathure Mberia have arisen in addition to the principal matters of pendency of court cases in them. Factual matters have arisen. To the factual question whether these people have been dismissed from office, the county executive says in charge of public service has been here and has adduced evidence that these people, some of them, their contracts ran out by a fluxion of time. That a contract that has ended. Number two, you are told the governor never dismissed these people. Good people, distinguished senators, would it have been easier than for the county assembly to present us with at least a sample dismissal letter of any of these people? The multiple volumes before you contain very many documents except anything in the name of a dismissal letter, even to prove that fact of an allegation of dismissal. You are going to make a decision this evening. I want you, in good conscience, to reflect on whether you can dismiss a governor for alleged dismissal of an employee without the dismissal letter before you, without an affidavit of that employee before you claiming to have been dismissed, and yet you are told, remove this governor from office. Correct. An allegation has been made that this governor deliberately and knowingly misled the public that 86 million shillings had been raised through pay bill number 247247, account number 04001639178999. First, let me contextualize that video. We had the opportunity to review that video, distinguished senators, and you are aware that other videos have been played to show just the amount of mud that was thrown at the senator, so at the governor, not by the family of the deceased, not by the wife of the deceased, but by persons, whether called activists or other leaders from Meru County. You listen to that clip and you have no doubt in your mind the governor is addressing those leaders who are throwing mud at her. I think that when I finally document the story of this governor, as I hope one day I'll get to do, she's the only leader who has been expected to have mud thrown at her with no corresponding right to respond. Because every time she responds to those very scurrilous attacks, she is brought here for impeachment. All of us had somebody claiming that a body of a deceased person would be placed in the home of the governor and to remain there, and if push comes to be brought to this Senate. How do we expect a fellow citizen not to respond? Human beings have an instinct of anger, have an instinct of shame, have an instinct of pride that is natural, normal human instinct. There's nothing inherently wrong in those human values. It's just the way God made us as human beings. And when the governor responds to those leaders, clearly saying those leaders must then support the deceased wife, build a house for her, buy her a car, start a foundation to support her children. I think, judged in context, that is a governor who is empathetic to this widow and who is calling for her to be assisted rather than being taken advantage of for political ends or possibly for business ends. I would want this particular charge to be understood in that context, distinguished senators. Ground number 3, at paragraph 8, an allegation is made of an alleged use of manual payroll. First, I think sufficient evidence has been laid here that this was an issue in the audit report. The County Assembly is yet to consider that audit report and recommend appropriate action or seek answers from the County Executive. Evidence has been laid to you that this governor inherited a government where manual payrolls were a systemic problem. In fact, she has finished that problem before this impeachment motion was filed. That is something I beseech you to keep at the back of your mind as you make a decision one way or the other on these proceedings. Evidence has been laid before you that the issue of manual register has appeared in audit reports in respect of an excess of more than 40 counties. What lesson do we learn from that? This may be a systemic government problem beyond Meru County. And therefore, the proper interventions by legislative and oversight institutions such as this is to provide systemic solutions. What can we do to ensure that IPPD numbers of staff are processed much faster to conduce an environment where payrolls are run without the necessity to resort to manual payrolls as we wait for IPPD numbers? You will empathize with the governor that if our government were to keep kindergarten teachers without salary for 8 months, pending processing of IPPD numbers by another government institution, that may as well be an unfair labor practice, which will also violate the Constitution. I have addressed the question of employing a bloated workforce. As a matter of fact, the governor has not employed a bloated workforce. As a matter of fact, this matter has been dealt before in a previous impeachment motion. As a matter of fact, evidence has been laid here of the governor's office rejecting other staff being sent to her office. I beseech you to keep that fact at the back of your mind as you make this decision. Finally, on the allegation of paying Kiambi Crispus Manyara, a public communications officer in the office of governor, full salary while in remand, distinguished senators, I want you in good conscience to make a decision whether governors pay staff. Just in the government organogram, whether a governor pays staff. The appointment letter of this particular staff shows that this is actually a staff of the County Public Service Board. That's the appointing authority, that's the disciplining authority. So that where a staff who is charged in court is supposed to be either suspended or interdicted and relevant communication made to the payroll team, that would be the function of the County Public Service Board, which is an independent board established as such under the County Government Act. To blame the governor for the failure or omission of an independent board, which, if the governor sought to interfere with, that may as well be a ground of impeaching her, that will be putting this governor in grave dilemma. We beseech you not to put this governor or any other governor in such a position of dilemma. The Supreme Court of Kenya, in the case of Sonko versus the County Assembly of Nairobi, set a principle, and I quote, though a political process, constitution, and the law, and it is not a platform to settle political scores. It is well within the rights of the governor to adduce evidence before you to show what political machinations are there, so that you can continue. My writing will not be on the 2/3 gender principle. My writing will be on the struggle to sustain a woman governor in Meru County. It is difficult for me to imagine of any public official in this country who has been subjected to the trials and tribulations of this governor. This governor who stands here, I look at her and see either my elder sister or my mother. I can't imagine of a lesson in resilience than that is embodied in this woman who sits here before you as governor. I beseech you to have the weight of this submission in your conscience as you grapple with the principal issues, the evidentiary issues, and the factual issues that I have raised this evening. I beseech you to acquit this governor on each of the 3 counts. I rest the governor's final submissions.
Thank you, Council. Now, honorable senators, ladies and gentlemen, we will now, pursuant to Rules 27 of the Rules of Procedure as contained in the 3rd schedule of our standing orders, we will proceed to a camera session. And therefore, at this juncture, I'll ask the parties to withdraw from the chamber, the members of the public to withdraw from the chamber, and the media to cease live broadcast forthwith.
Party leader Jimmy Wanjigi was on Tuesday afternoon released on a personal bond of 10 million shillings after he appeared in court.